Good afternoon, everyone. Welcome to the Appellate Division First Department. Our arguments for today, October 5. So we have 5.5 hours of argument time requested, so obviously that's not going to happen. Please, the normal spiel. We know your arguments. We're familiar with the briefs, so please just ask the time that you actually believe that you need for your arguments. Also, as you can see, we're a 4-person bench today, so that in the event of a tie, an attorney will be vouched in. Okay? A judge will be vouched in. We're not going to vouch in any attorneys. Thank you. So I'm going to call the calendar. Pacelli versus Peter L. Cedeno and Associates.
Ellen, 5-1, Your Honor. Although the respondent is not here, I'll submit unless the panel has any questions.
So that's a submission. Thank you. Matter of V. Children. That matter is submitted. Nash versus Walker Memorial. Respondent? 4, 2, and 5. Justice Kennedy is recused on that matter, and that matter actually would be called first. People versus Shaquem De Silva. That matter is submitted. Dynamic Event versus Penske Truck.
Respondent, 7 minutes, Your Honor. And if I may, my name is Thomas Newman. I would like to introduce my partner, Robert Columbus, a member of the Bar of the Commonwealth of Pennsylvania, who Your Honors have admitted Bohawk Beecher for this case.
Welcome. We have you remain standing for now. Yes, sir.
Respondent, Old Republic, 7 minutes, Your Honor.
Excellent. 5, 2, 5, and 5. Rodriguez versus Trinity Evangelical Lutheran Schools.
Defendant appellant 5 and 2.
You have a cross appeal? 5, 2, 5. Rosenbaum versus Myers.
For the plaintiff appellant, 5 and 2.
For the respondent, 5 minutes.
5, 2, 5. AIG Property versus SF Construction.
Appellant, 5 and 1, please. You want to respondent, 5 minutes.
5, 1, 5. People versus Matthew Nunez. 4, 1, 2. Lantern Endowment versus Peck.
Request 5 and 1, Your Honor.
5, 1, 5. Suzuki versus Greenberg. Going to submit?
Since respondent is not here, unless Your Honors have some questions, I'll rest on the briefs.
Are you Mr. Greenberg?
Yes, I am.
So that's a submission. Thank you. 75 Street Servicing versus CLST Enterprises.
Good afternoon, Your Honor. On behalf of the defendant's appellants 5 and 2.
I don't see a respondent.
I'd like to be heard regardless, if that's okay.
Sure, 3 minutes. Jorge versus the City of New York. That's a submission. People versus Ramon Rosario. That's submitted. Carboni versus Alfa Romero. Yes, sir.
Plaintiff respondent, but if the appellant is not here, I can submit on the briefs.
That matter is submitted. Wasi versus Wasi is submitted. So the first case for argument is Nash versus Walker Memorial. Justice Kennedy is recused on that matter. Justice Rodriguez is vouched in. Whenever you are ready.
May it please the court, my name is Ken Levine. I am here on behalf of the appellant, Walker Memorial Baptist Church. We had a contractual indemnity claim against the co-defendant. That's the Roslyn Yallow Charter School. We were a church that had a tenant that was the school. It was an injury and a personal injury action.
Counsel, we're talking about the settlement, though.
Yes.
Looking at the post-mediation agreement, which is Record 290, it says all claims are being settled, and then that was confirmed in a subsequent email from Walker's counsel, correct?
That is not an accurate view from our perspective, Your Honor, of the record.
I'm looking at the email.
Oh, I'm looking at the emails as well, Your Honor. And if
Okay.
we were to turn to that page 292, as you said,
Yeah.
I think the context of the bottom email that you're looking at may be something that is unclear, and that is
Which portion of that email would be unclear?
the entirety of it was one paragraph, Your Honor. And it is an email not from one party to another. It was an email sent by the insurance carrier for both of those parties to the two trial attorneys and said, "Nice job today, guys." You notice it's not directed to one party. It says, "Guys, great job today." And this is on,
Right, then Mr. Caulfield responds, right?
and Mr. Caulfield was the first to respond between the two, and he said, "Mike, thanks. We'll make sure that the paperwork encompasses all claims." That's fair. What were the material terms? None were given. Was there ever an actual offer? None were given.
What was the mediation then?
I'm sorry, I apologize.
A mediation happened,
Yes,
amounts were discerned, decided upon.
yes.
Those aren't material terms?
It was, but there was nothing given at all by the defendant, the respondent. There was zero. In other words, to be clear, my side gave $1.75 million to the plaintiff. The respondent gave zero.
Yeah, Rosalind was present at the mediation, was it not?
Rosalind was present at the mediation. and
Didn't
gave
you say,
zero.
Rosalind, you're going to kick in some money here?
We did ask them to. They said no. We have a contractual indemnity.
Okay, and then you
claim.
settled the case.
But that's what I do not understand. I mean, in hindsight, perhaps you should have said something to Rosalind, but we have a post-mediation agreement. And we have emails going back and forth talking about that agreement. So I'm not really sure now how you can say that there was no agreement. There was no
If
settlement.
I may,
agreement.
Your Honor, the emails that went back and forth afterward did not mention that mediation agreement at all. And you will notice the mediation agreement is nothing more than some scribbled words, and it's on page 290 of the record. And there's handwriting that mentions that there are certain claims that were going to be preserved. And that's on page 290 of the record. And on page 290 of the record, it mentions that there was a certain claim against Munich Re, who's the insurer for both the parties, that was going to be preserved. That was exactly what is written in this handwritten, by the way, again, Your Honors, it was a virtual mediation. It was something that the mediator sent out to everybody, and they didn't even get it until after this email exchange had occurred.
So, counsel, would it be accurate to say that emails began to fly once the mediation finished? Because I'm looking at the emails and, in chronological order, and the first one is on November 23rd at 4:16 p.m.
That is correct.
That the date of the mediation?
That's exactly right.
Okay, so the first one says, we'll make sure that the paperwork encompasses all claims, and
That
that's
was not,
from...
I apologize, Your Honor. That was not the first one. The first email was an email sent only from an insurance carrier attorney to counsel for the two parties, saying, "Good job, guys. Are we settling all claims? Are all claims being settled?" It wasn't between two parties. It wasn't someone offering something and somebody accepting it. It was an email from an insurance company asking the two guys if the third-party claims had been settled.
So this is November 23, 2021, 4:12 p.m. Brown sends an email to Caulfield asking him to confirm that the settlement resolves all direct claims and third-party claims, and acknowledged coverage issues remain viable and are not impacted by the settlement.
Your Honor,
Caulfield then replies that he will make sure that the paperwork encompasses all claims.
that is correct. That email that you read, though, Your Honor, was not from one side to the other. It was not from the respondent to the
It's from
appellant.
Brown to Caulfield.
Yes, Brown was not either of the parties. Brown was asking, as the insurance representative, whether or not things had been settled at the mediation or not.
Caulfield then emails Kohan to thank him for his assistance in settling the case.
Yes.
And added that the insured was very pleased it was over. Caulfield wished Kohan good luck with his efforts vis-a-vis recovery from Munich.
Munich is the insurer for the respondent, Your Honor.
Okay.
He was communicating that he understood that we would be still going up against the respondent. And the most important issue here is the first one in our reply, and that is there was no consideration. There was absolutely nothing paid for us to release our $1.75 million claim.
Well, that was, again, as my colleague mentioned, something that perhaps should have been mentioned during the mediation.
It was,
But
Your Honor.
you have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Dennis Valet, for the appellant, Louis Joes Avalon Villas LLP. I think that it's important to note that there's nothing in the record to indicate that the actual counsel for the appellant believed that he was not settling the third-party claims or that he believed that they were going to survive. In fact, everything in the record reveals that the counsel for the appellant believed that the entire case was settled, everything was settled, and that it was going to be insurance versus insurance in some sort of plenary action.
What was the consideration that Rosalind proffered for the settlement?
Sure. The most important one, of course, is the release of the contractual and common law indemnity claims that Rosalind Yalo Charter School had against all the other co-defendants. There was two third-party complaints in this action.
So Rosalind agreed to settle all claims against Walker. Is that correct?
That's correct.
Okay. And then Rosalind also, what else?
They also agreed to release all their claims against the other defendants. Now, it would make no sense for my client to agree to allow a indemnification claim to proceed against itself while releasing all of its competing indemnification claims against other co-defendants. That just doesn't seem to make sense to me at all. In fact, it makes more sense that all claims were resolved, as is stated in the memorandum, and then as is stated in the email from Walker's attorney.
So during the mediation, did Walker express any concern or any issues with the adequacy or inadequacy of Rosalind's consideration?
Thank you, Your Honor. There's nothing in the record that indicates that there was any complaint about what Rosalind was contributing to the settlement. And in fact, the only evidence in the record to that regard comes from the affidavit of the insurance carrier's attorney, who says that he made it clear that that was the case, but there's a affidavit from the counsel for Rosalind who said that it was not made clear. And if it was made clear, certainly that would have made its way into the memorandum, you would believe. And it just doesn't make any sense, and it belies all possibility that they would raise such a claim during the mediation and that it would be such an important matter, and then it wouldn't make its way into the memorandum and would only come to light after the fact the next day once the mistake has been realized.
So, counsel, a question. With respect to two particular emails, the one on November 24th, the two on November 24th, one at 9:25 a.m. and one 9:28 a.m. There's the first one at 9:25 is from Mr. Caulfield, who's counsel for Walker, to Mr. Kahani, who's counsel for Philadelphia Indemnity, and they say it says, "Good luck with your efforts vis-a-vis recovery from Munich." The response is, "Pleasure working with you. Obviously, don't discontinue the third-party action against the tenant." So there's no mention here of the tenant, and the tenant, I presume, was Rosalind.
That's correct, yes.
Can you explain the import of these two particular emails? I mean,
Yes.
there's more, let me just add, if I may. There's more that follow. I did not hear Munich object, and the one before that, I thought you were clear on Philadelphia's reserving its right to go against Munich, but there's no mention of Rosalind. So do you take them together, or do you take them separately and say that tenant meant Rosalind and Munich meant Munich?
I think it's important to realize that the insurance, the primary insurance for both Walker and Rosalind was Travelers, because Walker was an additional insured. So when you have Travelers making the first $1 million payment, they can't make it on behalf of Rosalind, as they are the employer of the plaintiff, and so it has to come from the additional insured. And now you have that $1 million is paid, and now you have a competing interest of who's going to be the next insurer to kick in. Is it going to be the excess insurance for the landlord or the excess insurance for the tenant? And when I read these emails about which excess carrier is going to be the first one to contribute, that is purely a Philadelphia indemnity versus Munich Re issue. And when they use the words tenant, they're colloquially referring to the insured party, but it's purely an insurance carrier versus insurance carrier priority of coverage claim. That's my understanding with those emails. And if Your Honors have no further questions, I'll rest on my brief.
Thank you.
Thank you.
May it please the court, I appreciate you asking about contribution because, again, the facts are simple. One side of a defendant paid $1.75 million to settle the plaintiff's case, and that case is settled. The other defendant paid $0, and this defendant had a contractual, not some contribution, but a contractual indemnity claim against this party. There would be no cognizable reason that we would ever, for no contribution, and there was no contribution, ever release our cross-claim of contractual indemnity against the other defendant. And so, let's go back to the law. There's no contribution for it. The only contribution that they've even mentioned here at oral argument is that the defendant who paid no money, and we mentioned it in our reply, exactly what their cross-claim was only if they ever had to pay any money to the plaintiff would they have an indemnity claim. They gave up nothing, and all that happened in this case was there was an email that the defendant, my defendant, replied too quickly with an email that will include all claims when responding to the insurance company person. Nothing was offered, nothing was accepted.
So again, when was that contemporaneous concern expressed by Walker about the adequacy of Rosalind's consent?
At the mediation, as noted in our affidavit of counsel for the insurance company that was going to be paying the money, at the mediation, they said if they're not going to contribute anything, we're never going to waive our indemnity over against them. There would be no reason to ever do it. It was mentioned, and it is identified in the record.
So then, when the emails are going back and forth, is there anything stated in those emails about the consideration?
As noted on page 292 of the record, that is when there was the response from this side to say, make sure you don't waive the claims against this side. And you asked, was there mention of any consideration? Never. Never was there a penny ever paid by this party. It's basic New York contract law. You need to give something to get something. And there was absolutely nothing given, so it was not an enforceable settlement agreement in this informal exchange of emails after the mediation. And for that reason, we ask that you apply New York contract law and find that there was no settlement. Thank you.
Thank you. So we'll go back to the calendar then. The first case on is dynamic event. I'm sorry? We'll just wait for Justice Kennedy to return. Whenever you're ready.
Good afternoon, and may it please the court. Walter Santiago, Jr. of Vogren and Freeman on behalf of Plaintiff Appellant, Dynamic Event Group, Inc. There are currently 3 issues before the court on this appeal. The first issue is whether the lower court erred in granting Penske's and Old Republic's motions for summary judgment on the basis that the matter was moot. The lower court cited to Coleman v. Daines as well as Penske and Old Republic for the position that a matter is moot unless it can reach an adjudication on the merits that would result in immediate and practical impact on the parties. Well, in this case, it would.
Can you slow down?
Sorry. It would quiet and it would stabilize the disputed juror relationship between Dynamic and Penske as it relates to present and future obligations. those being their insurance obligations.
So under the agreement, the renter assumes the risk of loss or damage from any and all causes, right? And the renter will also indemnify, yes?
I'm sorry, Your Honor, say that again?
I said, under the terms of the agreement, renter assumes the risk of loss or damage from any and all causes.
Correct, Your Honor, and that's Penske trying to shift their obligations over to the renter, including the insurance obligations.
So is it your view that the owner isn't required to maintain a policy, an insurance policy that meets the minimum, New York State minimum?
At least the minimum, Your Honor. That's under Vehicle and Traffic Law 370. And the law of that statute is very clear. It says shall, in order to the benefit of every permissive user. It doesn't say might or may. It says shall, and that's a peremptory mandate from the legislator. Penske and Old Republic also cite to cases like matter of Hearst Corp v. Klein for controlling authority. However, that is not controlling authority here. That matter involved a plea hearing that had already taken place at the time that petitioner submitted their petition to the court for a declaration that it was illegal to close that plea hearing, and so it wouldn't happen in the future again. The plea hearing had long concluded, and they were provided with a copy of the transcript, so there was nothing further that the petitioner would be entitled to.
So, counsel, the issue is Penske did in fact tender full payment of the plaintiff's expenses, yes?
Correct.
So then, and also defense costs.
Well, they tendered the defense fees incurred in the underlying action.
Okay, so now why isn't the controversy moot as the as Supreme Court ruled?
Well, if it was just a matter of defense and indemnity, perhaps it might be, but it's not just a matter of defense and indemnity. These are the parties that have a relationship, an ongoing contractual relationship.
But the relationship as to this particular incident and this controversy is ended.
Well, to this particular controversy because of indemnification and the defense fees that were
right.
paid.
So that's why, again, Supreme Court ruled that this controversy is rendered moot by the tendering of the expenses and the defense costs. So what you're kind of asking us to do is to give an advisory opinion as to future controversies.
Well, that's where the mootness exception would kick in because this is clearly a matter of likelihood of
under
repetition.
what circumstances or how would the mootness exceptions apply here?
Well, this is certainly a matter that's capable of repetition. As I said before, the parties are still operating.
It doesn't evade review, which is the second half of that phrase.
Well, actually,
how does it evade review, counsel?
Well, the lower court determined that it typically doesn't evade review because there's, doesn't evade review because of the brief nature. There's a brief nature of the violation here. You have a
I'm sorry, there's a what?
There's a brief nature of a violation here, so there's only 14
I'm sorry,
days.
say that again?
Brief nature of a violation.
Okay, thank you.
So you have a short-term contract that's only for 14 days. The lower court determined that here, Penske Dynamics should just wait and see, that the renter can tender and seek coverage from Penske, and then the issues will resurface. But here, the lower court determined that the matter was not typically going to evade review because a renter could always do that. They can always just tender to Penske, and then the issues will surface again. But again, we have a short-term rental agreement here, and this matter was just 14 days. So by the time of the expiration of that agreement, the violation has already taken place. If there's no accident, that agreement is not going to be challenged. And if there is an accident, typically it's of a low value. And so going on to the next prong of the mootness exception, substantial and novel, the lower court determined that the matter was not substantial and novel because of the low value of the claim. That supports the fact that these matters typically evade review because of the low value of the claims.
Thank you.
Good afternoon, Your Honors. May it please the Court, Robert Palumbis on behalf of the Penske entities. Your Honors, Penske has now satisfied all of the obligations that Dynamic contends Penske should satisfy under the statute. And so there's nothing left for the court to adjudicate. Penske has...
So, if I understand it, the appellant is concerned that your client is not going to maintain the minimum insurance policy that's required in New York State, but rather require it to litigate each time that there's an accident that falls under $10,000. Am I putting that right?
I think that you're accurately stating the concern, which is that in a
And they want us to issue a declaratory judgment so that your client is required to get insurance for each vehicle rather than see if maybe it has an accident, maybe it doesn't.
That's right, Your Honor, and that is an advisory opinion that's being sought. And here's why. Because it is contingent on some future event which is beyond the control of the parties, meaning an accident happening. There's no dispute with respect to this accident that Penske has satisfied exactly the obligations that Your Honor just described, which is a defense and indemnity of its customer. So what Dynamic is looking for is to get an advisory opinion that would apply to some other vehicle, under some other accident, and potentially even other customers. And that's precisely what the court can't do in a declaratory judgment action. There needs to be a live controversy. And here, there's no dispute that Penske has satisfied fully its statutory obligations as Dynamic sees them.
So what's your response to your adversary's argument that your client is evading its responsibilities under the law to maintain minimum insurance for each vehicle?
So first of all, Your Honor, I'd like to be very clear. Penske has insurance for each vehicle. It satisfies the statutory requirements to have insurance at the minimum amounts. What's at issue is whether the federal Graves Amendment preempts, according to
Graves is above, the Graves Amendment concerns amounts in excess of the minimum in the particular jurisdiction, yes?
No, Your Honor. And what it concerns is to preempt liability under state law anytime a lessor of vehicles is held liable where the lessor is not itself negligent or criminally engaged in some criminal conduct. So in the normal course, that happens through vicarious liability and under Section 388. But the effect is exactly the same under 370, and that was, at one point in this case, the dispute. It was, how does the Graves Amendment affect 370 and Penske's obligations? There is no longer a dispute with respect to the accident that occurred because Penske has satisfied the obligations as Dynamic sees them. Penske is fully indemnified and it's fully defended. And so this dispute, as pleaded and tried to prove up by the plaintiff, is over.
So now we move to the mootness doctrine and whether there's an exception.
Yes, Your Honor.
So Dynamic continues to rent vehicles, right? They have other Penske vehicles that they're renting.
Yes, Your Honor.
So why would the second prong not apply then? The first prong, that is likely to reoccur either between the parties or other members of the public. I mean, can you argue that it's likely or somewhat likely that the vehicle, one of the Penske vehicles, would get into an accident as well as like
right.
this vehicle did?
Your Honor, it's not likely, and the evidence we have for that is that there's a total of one case from the appellate term in all of the state that addresses this particular issue of the interaction between 370 and the Graves Amendment. And that was the evidence that the Supreme Court pointed to say that this is not an issue that repeatedly comes up in the context of all lessor-lessee relationships, much less just talking about Penske and one customer. Even if it were likely to arise again, it doesn't evade review, and that's because it is to the extent there is a violation, as Dynamic alleged here, that violation would continue, as it did in this case for 2 years until Penske fully satisfied its obligations as Dynamic sees them. So there's no timing problem here such that the issue would not be adjudicated if it came up again. If it comes up again, a court would have ample time to address it and resolve the issue at that point.
Thank you.
Thank you, Your Honors.
May it please the court, my name is Nicholas Herzler. I represent Old Republic in this matter. Your Honors, we definitely take issue with the mootness exception. First of all, under Coleman, the plaintiff needs all three of the exceptions, and it's our contention he does not satisfy any of the three, but in particular, substantial and novel exception, because of the fact that the appellate term in the 37 South decision fully addressed this issue in great detail. And although it's an appellate term decision, it was very well reasoned and it was very well thought out. It's also supported, by the way, by numerous other jurisdictions that have considered this exact issue of other states where the Graves Amendment interacts with minimum limits. And so it's not something that is substantial and novel. It's something that the appellate term discussed in detail and resolved. And so, and also evade review, like the plaintiff argues that, you know, because it was a short-term agreement that it would evade review. That doesn't make sense to me. And a short-term agreement can lead to a lawsuit, just like, you know, any other collision case. A lawsuit can happen when people don't know each other. They don't have to have a long-term agreement with each other in order to have a case against each other. And the New York court system, as this court is well aware, has entire divisions, the city civil courts and the small claims courts that are devoted to smaller claims of less than $50,000, or in the small claims case, less than $3,000. So just because it's a small, I mean, the lower courts are inundated with no-fault cases. So just because it's a small amount in controversy does not mean that it's going to evade review. And even if the court were to reach the issue of the Graves Amendment, obviously it's our contention the court should not reach that because the dispute has entirely been rendered moot. However, even if the court were to reach that, again, the appellate term in 37 South resolved the issue. All the other courts that have considered this, the 11th Circuit in the Garcia case, the South Dakota court in the subrogation division case, Enterprise Rent-A-Car matter in Maine, all these courts have come to the same conclusion. If it's a case such as this, where it's undisputed that the negligence of the driver, of the customer, was the sole proximate cause of the accident, then the Graves Amendment precludes that claim. We're not saying that that Penske does not have to have minimum limits. They absolutely do. If there's a situation where a Penske employee is driving the truck for some reason, or if there's an issue as to whether Penske did not maintain the vehicle properly such that there can be a negligence claim asserted against Penske, in such a case, then yes, they would have to have minimum limits, and that those minimum limits would need to be paid. But that's not this case. This is a case where it's been undisputed the entire time, ever since the complaint was originally filed, that the negligence of their employee was the sole proximate cause of this accident. Therefore, Graves applies, and all the courts that have considered this have come to that same conclusion. So I just don't see how the plaintiff gets around the mootness doctrine, but even if they did, the court should affirm on the alternative ground of the Graves Amendment and in accordance with 37 South. Unless the court has any questions, I'll rest in my brief.
Thank you.
May it please the court. What Penske and Old Republic are asking this court to do is to hold that the Graves Amendment preempts Vehicle and Traffic Law 370, which it does not. It preempts Vehicle and Traffic Law 388, which formally imposed vicarious liability on owners of motor vehicles simply because of their ownership.
Is that what 37 South Fifth says?
No, actually, there were two issues before the second department and 37 South. Those two issues were, number one, whether VTL 370 fell within the financial savings clause of the Graves Amendment, and they found yes, it did. So prong one was satisfied. They also determined the second question was whether whether a rental company can be held vicariously liable for the minimum amounts of insurance that fall inside of the Vehicle and Traffic Law, and they said no. But again, that is vicarious liability. It is not the insurance obligations under VTL 370. So 37 South is not controlling. Now, the Graves Amendment includes that financial savings clause, and the reason why the legislator did that is because of the McCarran-Ferguson Act. That is an act of Congress that says there is no act of Congress shall supersede or impair any law of the states that has been enacted to regulate the business of insurance, and that's exactly what VTL 370 does. There's three prongs to determine whether the McCarran-Ferguson Act applies. The first is you need a federal statute that does not specifically relate to insurance. Here, we have the Graves Amendment that does not relate to insurance. Its sole purpose was to end vicarious liability for the owners of motor vehicles when there was no negligence on their part or criminal wrongdoing.
Right, so McCarran-Ferguson would not apply.
McCarran-Ferguson, well, by virtue, VTL 370 would preempt the Graves Amendment, would reverse preempt the Graves Amendment by virtue of the McCarran-Ferguson Act.
You're arguing that it gives that McCarran-Ferguson gives priority to VTL 370, right?
Exactly, Your Honor. Well, not necessarily priority, but you can think of it that way because it's reverse preemption. They're arguing that the Graves Amendment preempts VTL 370, but Congress specifically said in the McCarran-Ferguson Act that there's no act of Congress that shall supersede or impair any state law that's been enacted to regulate the business of insurance, and that's exactly what VTL 370 does. Regulates the business of insurance as it applies to vehicles for hire, which is what Penske is. Thank you.
Thank you. Rodriguez versus Trinity Evangelical Lutheran Church.
Good afternoon, Your Honors. Andrew Kaufman from Miranda Sloan, Squire and Viveniotis, LLP, for the defendant appellant, Trinity Lutheran Church. This was a pre-deposition motion made in Supreme Bronx. It was supported by two affidavits, one a pastor from my client, one an affidavit from the tenant of the premises.
The trial court found that they were inadmissible. Is that true?
To be honest, Your Honor, I was a little befuddled by the opinion that they were inadmissible. I mean, they're in affidavit form. They're people with knowledge. They're people who have been at the premise for a period of time before the accident happened. The affidavits clearly defined the role of the property owner, and it defined the role of the tenant. The tenant, who is not a party because it's the plaintiff's employer, clearly averred that it was the tenant's responsibility to maintain the premise, that it was the tenant who would do the cleaning, the maintenance, the buffing, the waxing. The bill of particulars at page 54 of the record clearly states that the plaintiff's claim was that there was a waxy accumulation on the floor. That floor had been in for almost a year before her accident. The tenant acknowledged that it was the one who would buff and wax the floors. So to state that these affidavits were inadmissible clearly was an error. And I think there was a further error.
Well, the court ruled that they were inadmissible because the court stated they were not based upon personal knowledge or identifiable business records.
Well,
I'm just saying. I'm just telling you what the court said.
I understand what the court says, and that's why this court is here. I think it was an error. I mean, we attached the lease.
So the pastor stated in his affidavit that he addressed the ownership of the property and the cleaning of the floors, right?
He acknowledged that at paragraph 5 on page 36 of the record, the church has never maintained or cleaned that floor.
Right, and so then Ms. Morales-Thiem, she stated that LSNY maintenance is assumes sole responsibility for maintaining, repairing, and cleaning the accident site, including occasionally waxing the floors, right?
Yes, and I'm looking at page 33 of the record at paragraph 5 and paragraph 6. So, I mean, I think it was conclusively established with admissible evidence that...
Well, the court held that the plaintiff's statement that she saw defendant's personnel freely using the location, during the 3 years she was there, as well as walking across the location, showed that, well, at least they're presented, therefore, an issue of fact as to whether defendant had relinquished complete control over the area.
Your Honor, I mean, I don't really see that as a question of fact. If the pastor happened to walk through the area on an occasion to exit the building to get to a parking lot, that doesn't establish that it didn't relinquish control. It doesn't establish notice. It doesn't establish anything else. The plaintiff also speculated that because the school on occasion would use the church sanctuary for functions doesn't establish anything else. There's no dispute that the church issued parking permits to the tenant for the teachers to use the parking lot on a regular basis. There's just, to me, there was just nothing here that warranted the denial of the summary judgment motion. And in fact, if you look at the plaintiff's affidavit on page, I believe it's 82, if you look at page 83 of the record at paragraph 7, the plaintiff's theories are based on her, quote, her understanding.
Well, that's as to the structural issue, right? Because it was her understanding that defendant had recently replaced the floor where the accident occurred?
Well, that's actually disputed by her employer, who says that the New York City Administration for Children's Services installed the floor. So that's not a question of fact. You have to come up with something more than pulling something out of the air that it was her understanding or she was told this. You have to have proof. And in my opinion, the plaintiff offered no proof in this case.
Thank you.
Good afternoon, Your Honors. My name is Philip Reed. I'm from Sacco and Felis on behalf of the plaintiff respondent. May it please the court. There's no dispute here that the church owns the premises where my client fell.
But is that the sole inquiry, counsel?
No.
Okay, so now we have, on the motion for summary judgment, the defendants put in a copy of the lease agreement, which talks about who is responsible for what. They also submit the affidavits of the pastor as well as Ms. Morales-Thiam. Assuming those affidavits actually were admissible, what, if anything, did your client put in to raise a triable issue of fact to defeat the motion for summary judgment?
If I could just back up a second, Your Honor, I'd like to direct your attention to the lease. Specifically on R39, there's a paragraph entitled Access by Landlord to Premises.
Under the terms of the lease agreement, LSSNY will engage in those activities subject to the defendant's right to re-enter, to inspect, provide necessary services, or show the unit to prospective buyers. LSSNY was responsible for keeping the premises in good repair, all utilities and services, including garbage removal, etc. Defendant did not assume any liability for the care and supervision of the premises under the lease agreement. So what's the...
Well, on R39...
So how does the lease agreement show that there was any responsibility on the part of the church?
Well, they have the right to re-enter, Your Honor.
To inspect, provide necessary services, or show the unit to prospective buyers, mortgages, tenants, or workers.
Right, and just a little further, in case of an emergency, they could enter without the tenant's consent. In terms of the other documents you were discussing...
Okay, so then we move on to the two affidavits.
Right.
The pastor submitted an affidavit attesting to LSSNY's exercising control over the premises, employing its own facilities staff to maintain the premises.
That's right. I would direct the court's attention to R36, which is paragraph 4 of the pastor's affidavit, in which he states, church representatives can walk on that floor.
Okay, so the fact that they can walk on it, how do we get from walking on it to actually causing the waxy buildup or waxing the floor, which allegedly caused the wax buildup, causing the plaintiff to slip and fall?
Right, and that's of course not solely determinative. The issue here is.
Well, let me just stop you 1 second. How do we then reconcile that with Morales-Thiem's affidavit, wherein she says that they're responsible for the maintenance of the area, including cleaning, waxing, et cetera?
Right, well, plaintiff's affidavit says that the owner, the church, had done the asbestos abatement and done the floor modifications in the location incident.
But she's not, the floor modification, she stated that was based upon her understanding. I don't know where that came from. But she's not claiming any structural damage or anything that because the floor was replaced, that led to the waxy buildup. She says that she slipped and fell on wax, right? She doesn't talk about that, it was sloped a certain way or the floor had not been constructed, properly. She says wax.
That's right, Your Honor, but.
She said an accumulation of wax and was extremely slippery.
That's right, Your Honor, but the issue here is, there's potentially a coefficient of friction argument that was argued below, and the motion was made prematurely. On cases like this, there's a great imbalance between what the plaintiff knows and what the premises owner knows. This is not a hit in the rear.
I'm sorry, did you put in an affidavit from an expert talking about? No.
No, just the opposite, because they didn't allow us to inspect the premises, they didn't allow us to do any depositions. The motion
So
was.
the only thing I saw in terms of your motion to defeat defendant's motion for summary judgment was an affidavit by your client basically talking about the fact that she had seen individuals from the church walk in that area, that there had been asbestos removal by the defendant, and that she had an understanding, it was her understanding that the floor had been replaced. Was there anything else that went to the maintenance of the floor or the daily maintenance of the floor?
No, Your Honor, the plaintiff also said that she was issued a parking permit. But again, the issue here.
Parking permit for the hall on where she fell?
No, Your Honor.
Parking permit for like a parking lot outside?
Right, that's correct. That's correct. But again, the issue here is that the motion is made prematurely. The plaintiff's expert did not have the chance to inspect the floor at the time that this motion was made. We don't have any expert testimony on the record.
Why does it matter if you're talking about what the plaintiff alleges was a wax buildup? An accumulation of wax and was extremely slippery. What else would you put in? What else would be necessary other than the records or the testimony as to who was responsible for waxing the floor?
Well, again, it goes to this potentially coefficient of friction issue that was briefed below. You could have some type of structural or design defect with the floor, where maybe there was a divot that led to the wax.
Counsel, if I may, you talk about a structural defect, a design defect, but that was never alleged in the complaint or the bill of particulars, correct? No, that's a yes or no.
No, Your Honor, it was not in the bill of particulars. But again, the purpose of discovery is to supplement.
Let's go back to the complaint. Was that alleged in the complaint?
No, Your Honor.
Thank you.
If I can just respond to this prematurity argument that was raised. If the plaintiff truly believes there was a coefficient of friction issue in the case, that goes back to the tenant as per the affidavit of the tenant. It doesn't go to the church. It's the tenant who's doing the waxing, the buffing, the maintenance, and the cleaning of the floor. It's not the church. Thank you.
Thank you. Rosenbaum versus Myers.
Good afternoon. May it please the court. Andrew Steinmetz on behalf of plaintiff appellant Thane Rosenbaum. This case concerns the enforcement of a February 7, 2005 acknowledgement of debt, which creates an unambiguous contractual obligation for the defendant to share with the plaintiff 25% of the net profits.
Defendant says that your interpretation of the AOD requires extrinsic evidence, and therefore it's not clear on its face. Do you want to respond to that?
Your Honor, we disagree with that argument. We think the AOD is clear on its face. It is unambiguous. It refers explicitly to assistance, guidance, and time, the extensive representation and advice and negotiations with the City of New York, and the financing and development of the property. It is a specific property that is at issue. There's no other advice or communications with the City of New York that would be relevant here. That language.
That's the wrench, right?
I'm sorry?
The wrench here is the fact that at some point in time, the argument is that at some point in time, your client may have assisted the defendant in her matrimonial case, right?
That's correct, Your Honor.
And that perhaps the monies are owed to the defendant, perhaps the agreement is in actuality an agreement to repay your client for his assistance in her matrimonial case.
That is the contention that the defendant has been advancing for the last 4.5 years of this litigation. It remains at odds with the plain terms of the acknowledgement of debt. The acknowledgement of debt is much broader than a retention agreement or an agreement to pay legal fees for representation in a divorce proceeding. The words
Counsel, what about
divorce and...
I'm sorry to interrupt you, but what about the complaint? It's a verified complaint, and verified by Mr. Rosenbaum. And in paragraph 14, it sounds a little bit like he's saying that everything was done pursuant to the matrimonial action. So that was, at the beginning of the lawsuit. I'm paraphrasing, and there's probably other ways to interpret that paragraph. But it makes it sound like all of this happened within the context of the matrimonial action, which is, of course, what the other side says.
So, Your Honor, I would point you to page 223 of the record, the verified answer and response and counterclaims from the defendant. There is no dispute that on June 7th, 2004, which is when the stipulation of settlement in the divorce proceeding was entered into on the record, it was entered into orally. The transcript is in this record. Mr. Rosenbaum was not representing Ms. Myers. That is
Mr. Welts was. Mr. Welts was the attorney at that time.
That's correct, Your Honor. Mr. Welts is a matrimonial attorney. Mr. Rosenbaum has never practiced matrimonial law. Indeed, it's undisputed. He is not even a practicing attorney. He has a law license. He's a writer and a law professor, and actually everyone seems to be a lawyer in this case, Your Honor. The defendant is a lawyer. The defendant hired several other lawyers. She hired an additional lawyer to help draft this AOD. There is undisputed evidence in the record that
Of course,
shows...
she says that it was dictated, the AOD was dictated by your client. Do you want to respond to that?
I do, Your Honor, and I think we've responded in our papers, and I'll respond here. There is undisputed documentary evidence in this record that shows the AOD was drafted in consultation with a separate attorney. The billing record from Mr. Berkman, which is at page, I believe it is 500. I'll get you the citation on rebuttal, Justice Moulton, but there is a billing record in this in the record here that shows Mr. Berkman, the attorney who Ms. Myers hired, had conversations with Ms. Myers to draft the agreement and confirm the profit-sharing obligation that it embodied. So we think with that evidence, this shows that this was a deliberate, validly executed agreement. The four corners of this agreement are not really in dispute.
Have we previously, has this court previously ruled on this case, in terms of the AOD and the contingency, the matrimonial?
It has indeed, Your Honor. This court reversed a decision by the court below, when the court below granted I see I'm out of time, I'll just briefly conclude.
Continue.
The decision, I would point you specifically to language in the decision from the prior appeal that noted the relevant circumstances that compelled the conclusion that the court reached in that case, in that decision. It references specifically the plain terms of the agreement, the timing of the execution, the fact that they were romantically involved, the fact that he was not a matrimonial lawyer, the fact that he only became counsel of record months after this AOD was entered into. All of that is undisputed. It remains undisputed. And for that reason, Your Honor, we think this case is simple. And summary judgment certainly should not have been granted to the defendant. If anyone is entitled to summary judgment here, it is only the plaintiff.
Thank you.
Thank you.
May it please the court, I'm Jethro Eisenstein. I represent Rosalind Myers. There's a peculiar statement in appellant's brief at page 27, footnote 3. They refer to some, quote, uncompensated services at the time they were performed. Services, particularly legal services, are either compensated or they're not compensated. There's no in between.
So, counsel, my recollection is that your client said, I never expected to be charged anything with for the matrimonial action, and the plaintiff says, I never charged her for any work in the matrimonial action. I think there was only one appearance because her retained lawyer was unavailable. Am I off the mark?
First of all, the plaintiff said, when he began representing me, I didn't expect him. But she then continues to say that he then undertook to seek compensation. He is here.
No. I'm talking about the matrimonial action, not the work that was done relative to the Lennox property.
No, the matrimonial action, the record that's before this court now shows that starting in September of 2004, 2 months after the stipulation was orally made, Mr.
Stipulation pertaining to the divorce.
I'm sorry?
Stipulation pertaining to the divorce.
To the divorce, Mr. Rosenbaum stepped in, his words in the complaint, and began representing Rosalind Myers in the divorce action, and was the only attorney representing her from September through May. If you look at page...
What about Mr. Weltz's, Mr. Weltz didn't leave the case until May 25, 2005, right? There was an actual, exchange of counsel.
There was a substitution then, but as Mr. Rosenbaum's attorney has conceded, and I'll give you the page site, it's not the rules apply. The matrimonial rules don't depend on substitution. If someone, in fact, is representing a person in a matrimonial action and is now seeking compensation for that representation in the matrimonial...
Counsel? How many appearances were there that you're in the matrimonial action?
Your Honor, there were no appearances, but that's not the measure, Your Honor. The measure is he, according to the affidavit of Mr. Monteleone, who was of counsel to the plaintiff, the only lawyer who was representing Rosalind Myers in the negotiation of the settlement agreement that led to the divorce judgment from September of 2004 until through the end of the case was the plaintiff. So the rules, the application of the rules does not turn on...
If attorney represents a client free of charge in a matrimonial action, do the rules apply?
No, but Mr. Rosenbaum did not represent her free of charge. He is here, according to his verified complaint, seeking compensation for representing her in the matrimonial action.
Does our prior decision impact the issues at all? Because I thought that our prior decision stated that there was no matrimonial relationship, in that your client was not the attorney, a matrimonial attorney. Did we not say that in the decision?
No, you said specifically what you said.
Defendant also admits that she did not expect plaintiff to charge her for his legal assistance.
But in fact, that's
in
not
her
what she
divorce.
said.
No, I'm not reading. I'm reading from the decision of the appellate division.
No, I understand that.
And it
Judge.
says, further, the record reveals that plaintiff, who was romantically involved with defendant at the time and not a matrimonial lawyer, only became her lawyer almost a year after she and her former husband had already entered into a oral stipulation of settlement.
The current record contradicts that, Your Honor.
But I'm looking at our prior decision where we made that determination.
I understand.
In reversing the Supreme Court.
Your Honor, all that this court decided was that a 3211A1 motion based on documentary evidence did not utterly and conclusively rebut the defendant's defense. That's
But
all
counsel,
that was-
you're out of time, but I do want to, if you could just point me to where in the ALD, right, specifically why we would read that just to come to a conclusion that there was that any monies were owed based upon representation, legal representation for the matrimonial action.
It says,
This debt arises as a consequence of the extensive representation and advice in all legal proceedings and negotiations with various parties, the City of New York, and the financing and development of the property.
Your
And it
Honor.
also says above that, for consideration arising out of the invaluable assistance, guidance, and time which enabled me to purchase the Lennox.
Your Honor, it also says that it's arising out of the services that the services provided in the divorce, and the only
Where?
Does it say that?
Where does it say that? I'm sorry. Where does it say that?
And I mean, we're talking about two lawyers, counsel, aren't we? Your client is also a lawyer.
Your Honor, my client is a lawyer.
So, counsel,
where is it?
Could you just point to where it states in that ALD? And I just want to make sure we're looking at the one that was executed on February 7, 2005. There's no other ALD, acknowledgement of debt. So where in that acknowledgement of debt does it talk about the matrimonial proceedings?
It says, if I can borrow from from my adversary, the record.
Counsel, I think I can help you out. It says all legal proceedings. And so
says
in your
all
brief, you
legal
say that that
proceedings.
does mean the divorce case, but the word divorce, of course, does not appear in the AOD, right?
But it says all legal proceedings and negotiations with various parties arising out of for the financing and development of the property.
And Your Honor, first of all, as you can see from my brief, it is all of those services, other than the service in the matrimonial action, are disputed by the defendant. So the notion that that is conclusive on this subject.
But she wrote it in the AOD, or she signed the AOD, and so she's acknowledging
signed the AOD, and
that happened.
And there's a separate issue, which I don't think the court needs to decide, because this is about representation, and you can't be a pro bono lawyer when you're claiming compensation for
we get it. You're
representing.
saying this is
Counsel,
like
if I may, also in the prior decision, this court also noted that the plaintiff's involvement in the actual divorce proceedings was limited.
But the record is different now, Your Honor.
So, counsel, what was your argument? You can't be a pro bono. I didn't understand that. She's an attorney. As my colleague mentioned, she's an attorney. Mr. Rosenbaum was an attorney. They drafted this AOD, or at least it appears that she drafted the AOD. So we can't take into consideration the fact that she's an attorney and shouldn't have known or was cognizant of what she was writing in the AOD?
Your Honor, first of all, as you will have seen from my brief, And from the record in this case, she has stated under oath that the AOD was dictated by him and that she was told by him to go to an attorney and have it formally drawn up, and that she did that because she was under severe psychological pressure from him, having threatened to reveal information that was relevant to her custody of her children, and that she did it only for that purpose.
So, counsel, if we take that in context, right? The acknowledgement of debt is dated in 2005. The property was purchased in the year 2000 by your client when she was then married for $513,000 plus. At the point where it's sold for $3.78 million in 2016, 11 years later, your client and the plaintiff are still involved in a romantic relationship, and it's after the sale, when the 25% is owed, that apparently your client doesn't want to honor her part of the bargain. So during all the 11 years between the time of the sale and the time of the acknowledgement of debt, did your client do anything to undo the AOD and say, this was a terrible thing that I was forced to write? I'm a lawyer, but he made me do it?
The record reflects that she repudiated it, and that's at page 234 and 572 of the record.
When did she repudiate it? Before or after they broke up?
I'm sorry?
When did she repudiate it? Before or after they broke up?
Within moments, within weeks of the signing of it in 2005. That's part of the record. She repudiated it, and from 2016 to 2019.
Where's the repudiation, counsel? What page in the record?
It's at page 234, and again at page 572.
And how did she repudiate this? In writing?
She tore it up in his presence.
Oh. I see. Thank you.
A few very quick points, Your Honor. First of all, on the last point that my colleague was just referencing, the alleged tearing up of this AOD, that appears nowhere in the record other than in Ms. Meyer's own affidavit.
Well, that would certainly constitute a repudiation if she tore it up.
Well, Your Honor, there is nothing that substantiates that allegation. It's her burden to actually provide evidence on a motion for summary judgment.
What is she going to provide? The torn pieces of the AOD?
Well, I think the critical piece in the record, and I promised Justice Moulton a record site, it's at record page 174. Those are the documents that concern Ms. Meyer's exchange with Andrew Berkman. In 2016, and then again in 2020, during the course of this litigation, Ms. Myers reached out to Andrew Berkman asking him to destroy the AOD. That, I think, is consistent with her contemporaneous understanding that this was a valid document. This was a valid contract. She had entered into it with counsel, and after the fact, after the relationship had soured in 2020, she emails her lawyer during the pendency of this litigation, when she had an obligation to preserve documents. She emails this attorney to say, actually, can you please destroy the copy that you've retained in your files? I don't think that is at all corroboration for the bare assertion.
So you're saying there's nothing else in the record. Of course, tearing up a contract doesn't make it go away, usually. And there are other tearing up a contract usually does not make it go away. Right. You have other things you have to do to show innovation or get out of a contract in some way. So is there anything else in the record that backs up what this tearing up and then any other thing that she did to get out of the contract or say it was a product of coercion or anything like that?
There is nothing else in this record, Your Honor, and I think the surrounding circumstances and the facts, Justice Gonzalez noted several of them, including their continuing relationship, living together, raising their children together for a decade after this, alleged tearing up and repudiation. It's just inconsistent with that story, which is simply an allegation in an answer. Very quickly, if I could address.
No, we're finished, but thank you so much.
Thank you, Your Honor.
AIG Property versus SF Construction.
Good afternoon, Your Honors. May it please the Court. My name is Matt Minero, and I am the attorney for the appellant, SF Construction. We are here seeking a modification of the Supreme Court's order on our motion for summary judgment, which limited the application of a waiver of subrogation provision to the work itself, which was a limited subsection of the entirety of damages. We believe that the clear, unambiguous terms of Article 17 of the agreement between my client and plaintiff subrogor show that the insurance that was supposed to be procured by the owner was for the entire project.
So the waiver of subrogation clause waived all claims for damages caused by fire to the extent covered by property insurance obtained pursuant to Section 17.3 or other property insurance applicable to the work.
Correct. However, if you look at Section 17.1, 3.1, it talks about that what's to be protected under the insurance. It's all of the interests of the owner, the contractor, which is my client, in the project. Project and the work are not, do not have the same definitions with respect to the contract.
But the project is defined sort of by default as her apartment, right?
Correct.
But I mean, wouldn't it have been better, and I guess we always ask her these questions, to just say, and it's not going to cover her whole apartment, or it is going to cover her whole apartment. In other words, to say it more explicitly than by this inferential way that you ask us to adopt.
Well, of course, yes, of course, Judge. However, there is a distinction and a difference between work and project. And with all due respect to the Court of Appeals in Brisk Waterproofing, which seems to be the seminal case, they do address not the actual waiver of subrogation, but they look at what was the owner required to procure with respect to the scope of the insurance. And here, the insurance that the owner was supposed to procure was to protect the interests of everyone in the project. Project is 75 Central Park West, Apartment 9C and D. It's not just the work. Work has a very different definition here, and it's really as simple as that. The procurement provision.
So you're saying that the fact that the term work and the term premises are used should be interpreted by us as saying work and premises?
Work and project, yes.
I'm sorry,
it's okay.
work and project.
Yes, I understand. Yes, I believe that there is a distinction between those terms, and if you acknowledge and recognize that they are defined differently, the insurance that the owner was required to procure was to protect the project, which is everything within the apartments, not just the work. So to limit the waiver of subrogation to the work is an improper reading of Article 17.3, point 1 and point 3.
I'm looking at another case that involved SSDW.
That's the Brisk Waterproofing case, yes.
Yeah, so it says here that that the court recognized the difference in the respective interests of the owner and contractor under an owner's property insurance policy during the course of construction. Under Tishman, the contractor's insurable interest in the insured building extended only to the tools, labor, and materials which it had furnished, and the owner's insurance of the insured's right of subrogation was barred only to the extent of that insurable interest. So how are these different?
Correct. It's again, it goes back to there being a distinction between work and project. In Brisk, the insurance procurement obligation of the owner was only to protect the work. Work is defined there as tools and whatever of the actual work itself.
So in SSDW, the owner was supposed to maintain property insurance upon the entire work at the site. Here, 17.3 requires that the owner maintain property insurance comprising the value of the entire project at the site.
Yes, and Your Honor, I believe even the last sentence of that paragraph is even more instructive, in which it says that the interests to be protected are, I see my time is up, may I finish?
Please.
That the interest that's to be protected is owners, contractors, which is my client, interest in the project. The project is the entire apartment, not just the work. Thank you.
Thank you.
Good afternoon. May it please the court, my name is David Smith. I represent the respondent AIG Property Casualty Company as the subrogee of Amy Irving, who is the owner of the apartment.
So what I found interesting is that you both rely on SSDW.
Well, I relied upon this. My firm did the case in SSDW 35 years ago or so. And the thing is, it carved out an exception that says for the work that's being done, the waiver is applicable. If it's beyond the scope of the work, it's beyond the terms of the contract. Well, looking at the AIA contract, the contract was a limited contract for renovation. It wasn't a full renovation of the entire apartment. It was limited. And if you look at the contract, there's a whole thing in there with scope of work. And in there, it delineates exactly what the work was being done in the apartment. And in fact, we had our expert who evaluated the property damage. He broke up and looked at the damages that were sustained with the scope of work, and there was a carve-out.
That's an important point because that's how you distinguish the Trump equitable case, correct?
Right. And the thing is that the court reduced our claim of damages by over $200,000 because that was within the work. And if you look at 7.3, it says, the work may constitute the whole or part of the project. They're delineating a project. The project may be, they could just name it the Irving apartment. But the point was, it wasn't it wasn't a gut renovation. So the thing is, under 7.3.3, which is the clause that has the waiver of subrogation, it specifically goes into, and I think you quoted it earlier, covered by property insurance obtained pursuant to section 17.3, applicable to the work. And since 7.3, which defined work, says the work may constitute the whole or a part of the project, and then you look at what this, in the contract, if you look at what the scope of the work is, then you could see that the waiver is only applicable to the work. There was sufficient insurance. Ms. Irving complied and provided insurance for the project, but the point was that the waiver, and you have to look at the language in 17.3.3, only applies to the work. It doesn't say that the waiver applies to the project. And I think that that's the court, Justice Hagler was correct in his decision where he basically applied the SSDW versus Brisk waterproofing case to show that pursuant to the terms of the AIA agreement, the waiver is only valid for that which damages.
Counsel, let's turn to the other issue in the case, which is why do you all get to keep the deductible?
What?
The other issue is you're also asking for the deductible, which is something Ms. Irving was out of pocket, not you guys. So why do you get to keep it?
No, as a matter of course, on any case, we include the deductible in the claim. It was included in the complaint.
You're going to give it back to Ms. Irving?
It's going back to Ms. Irving.
All right.
That's pursuant to, in the policy, but it's also in our complaint, we state that the claim was for this amount of money, which includes the deductible for Ms. Irving. Ms. Irving, whatever recovery would be obtained, she would get a prorated share of that recovery. And the thing is that, notwithstanding, we don't think that the waiver of subrogation clause would be applicable, but the thing is, even if the court did so, under the Red Apple case, that the deductible would not be subject to a waiver.
Counsel, since your firm handled SSDW way back when, you thought you could have drafted a better agreement in this case, You knew, yeah.
Well, the agreement was prepared by...
So that we wouldn't have to deal with the work in the project, or we would know exactly what we're talking about?
Let's put it this way. Ms. Irving individually was, SF Construction was the one who prepared the document. They use an AIA agreement. And the thing is that individuals, they don't know about with subrogation and all that. They follow whatever, it's a form agreement.
No, I know, and so, we encounter these cases constantly, and it always boggles my mind that folks don't, learn and perhaps stop using these boilerplate
Insurance
agreements.
company lawyers need to talk to the construction lawyers, is what Judge Weber said.
That is true, and there's also, I just have one other comment. I mean, they relied upon one case, I think it was Moo chapter, and that one they relied upon with an AIA agreement, which basically was modified after SSDW to include adjacent properties. However, in this case, that language that was in the fraternity case was not in this agreement. So the thing is, you have to look at what this agreement says and apply that with SSDW.
Thank you.
Thank you very much.
Thank you. Just really briefly, in order to limit the waiver of subrogation to just the work, the court has to read out the term project, which was defined as the entire project, the entire apartment, not just the work. If you look at brisk waterproofing, as you did, it actually relies on Trump Equitable, which is the decision before it. And what it says there is that depending on how work is defined is the issue. But there, the only term being defined is work. Here, this contract, whether or not it was intentional or not, says project. The insurance must cover the entirety of the project. This insurance covered the entirety of the project.
So, counsel, I'm sorry. In section 17.1, it does say any claim for damages other than to the work itself. So don't you see that language as creating two categories? Work is one, project is another?
I'm sorry,
I'm looking at section 17.1 of the contract. It said that SF had to obtain insurance covering, yes, among other things, any claim for damages other than to the work itself.
Yes.
So
absolutely.
There is a distinction, right?
Well, there they are talking about the difference between first-party insurance and third-party insurance. Respectfully, in 17.1, there's an obligation by the contractor to get third-party insurance, meaning if, which actually happened in this case, yes, there was a fire, there was smoke damage, went upstairs to Hank Azaria's apartment. That's where my client's insurance coverage was required to come in and pay, because while I might be disputing between myself and my subcontractors as to who is responsible, it's our project, we pay. In 17.3, which is for the property insurance, that obligation to provide property insurance is specifically assigned to the owner, and it's for the entirety of the project. This whole thing is, is the word project. That's the key here. And project is defined as the entire project, not just the work.
Thank you.
Thank you.
People v. Matthew Nunez.
May it please the court, Clara Hammond Oakley on behalf of Appellant Matthew Nunez. Your Honors, I'm asking that you reduce Mr. Nunez's probationary sentence in the interest of justice here. When he was arrested, he was only 19 years old, and he had absolutely no criminal history whatsoever. Not only no convictions, no adjudications, he had no prior arrests at all.
Oh, the arrest was for a loaded 380 Smith & Wesson loaded with a magazine containing 6 cartridges, and this was on the street, 6:59 p.m., East 167th and Tiffany.
Yes, Your Honor. And Mr. Nunez pled guilty to possession of a firearm.
Right. Well, it was a plea bargain. He was allowed to plead down to the criminal possession of a firearm, as opposed to the criminal possession of a weapon, wherein it would be 3.5 years. He was allowed to plead down based upon the fact that he was 19 years of age at the time, and I'm assuming there was some type of pre-sentence, pre-pleading report that he had undergone counseling. He was employed. It must have been a pre-pleading because he went through Bronx Connect, and so he had also had issues in terms of prior hospitalizations, et cetera. So he's allowed to plead to the criminal possession of a firearm, and he is given 5 years probation. So, I mean, that's a benefit of the bargain, is it not?
I think it is a benefit of the bargain, Your Honor, but I think that it still can be true that 5 years probation for Mr. Nunez, given his background, given his conduct while his case was pending, can be deemed excessive by this court.
Excessive. So when would he complete probation?
He would complete it in December of 2024. So
December 2024.
Yes, he will have done 4 years this December.
And based upon his history, is supervision not appropriate?
I think that some supervision is appropriate. I think that 5 years is too much supervision. I mean, this case started in 2019. That was a long time ago at this point. That was before COVID happened. I think that from 2019 up until now is a sufficient period of supervision for somebody like Mr. Nunez, who had no prior criminal conduct before then, who didn't have any while his case was pending.
You just happened to have a loaded Smith & Wesson on the street at 6:59 in the evening. So in order to reduce the sentence, do we have to look to the waiver?
I don't think that the waiver should affect this case. I don't think that it was a valid waiver here.
Why was it not a valid waiver?
Because Mr. Nunez, again, at the time that he took the plea, was 20 years old then, but he still was somebody who had demonstrated intellectual challenges, who hadn't graduated from 10th grade, and who had never been through the criminal process before. He had never been charged with a crime before, and he had never taken a guilty plea before. So this was all new to him.
Well, this was the model colloquy that was done by the court in terms of the waiver.
Yes, Your Honor, it was very close to the model colloquy. However, it occurred after Mr. Nunez had already admitted in open court that he possessed a firearm. Mr. Nunez was, at a great disadvantage.
We've upheld appeal waivers that have been taken after a plea, right?
Yes, Your Honor, and I'm not asking for any sort of per se rule here that that's not allowed. What I'm saying is that it's one factor in combination with Mr. Nunez and his background that makes it so that this plea was not voluntary and intelligent. Prior to pleading guilty, Mr. Nunez did sign a written waiver. However, the court never inquired as to whether he had read it, whether or not he understood it, whether or not he had any questions about it. The court then elicited admission from him that he had a firearm. And I think the court has to understand that that was the only chip that Mr. Nunez had, right? Like, all he could do was remain silent, refuse to plead guilty, and hold the prosecution to their proof.
I'm not understanding. So we are to then conclude that although he answered affirmatively to the questions as to whether you understand the waiver, whether you are giving up you understand you're giving up your right to a trial, right to have a trial by jury, et cetera, that we are to conclude that all of those statements were not made knowingly?
No, Your Honor, I don't think that you have to conclude that all of those were not made knowingly. I think that as to the waiver of appeal specifically, you can conclude that we can't be certain based on this appellate record that Mr. Nunez, prior to admitting guilt, knew exactly what the waiver of appeal entailed, you know, what his right to appeal was, what the consequences
There's a
of the
written
waiver
waiver
would
to
be.
appeal as well, right?
Yes, there is, Your Honor.
Thank you.
May it please the court, Oliver Lee for the District Attorney's Office. Your Honors, the waiver here is valid. This court doesn't even need to consider a defendant's excessive sentence claim. However, even turning to its merits, the defendant received an exceedingly fair sentence of 5 years probation rather than the mandatory incarceration that he faced. Additionally, defendant's background indicates he would benefit from the guidance and supervision of probation. As my adversary noted, the defendant only completed a job readiness program and counseling after this arrest while under the guidance of his attorney and under the supervision of the court. Before his arrest, the defendant admitted to problematic conduct, including getting suspended twice from school, dropping out of school, and having anger management issues that resulted mostly in property damage. Your Honors, the defendant's sentence is fair, and if there are no questions, I would rest on my brief and ask this court to affirm.
Thank you.
Counsel, if I may, I want to go back to the waiver because it was the defendant and his counsel that represented to the court that defense counsel spoke to the defendant about the waiver. He understood it. They reviewed it together, correct?
Your Honor, I believe that he said that he had spoken about the waiver with his attorney. He never said that he had spoken about the written waiver of appeal. He never made a statement that he had gone through that form with the attorney.
My notes say that defense counsel said that they filled it out, they reviewed it, they discussed the matter, and then following up on what Justice Weber said, there were questions by the court. And defendant said, yes, he spoke to counsel, and he understood what he was waiving.
Yes, Your Honor, and those questions, that back and forth with the court happened after he had already admitted that he possessed a firearm, and I don't think it's fair to infer that somebody in Mr. Nunez's position would have felt comfortable at that point saying, oh no, never mind, I didn't
Are
understand.
there any cases that say that you have to go through the colloquy before the defendant actually does the factual allocution?
There are no cases that make it a per se rule. However, there is a case in the Second Department and a case in the Fourth Department that I cite in my brief where it is one factor that the court considered in deciding that the waiver was
Because
invalid.
I've never seen an allocution where you would do the factual portion of the allocution after you do the right to appeal. But I mean, I'm not understanding how there's any prejudice, but I mean, I'll certainly take a look at those cases. Thank you. Thank you both.
Thank you, everyone.
Lantern Endowment versus Peck.
Good afternoon, Your Honor. May it please the court. I'm Matthew Press of Press Corral LLP for defendant Ian Peck. Mr. Peck appeals from a $463,000 default judgment entered against him personally on contracts between plaintiff and two business entities, both of which were later dismissed from the case. Now, a defaulted complaint is deemed an admission of liability, but it is well established that the plaintiff must meet its burden of proving damages, in this case, contractual expectation damages. The trial court should be reversed because it denied Mr. Peck his right to cross-examine his accusers in a valid inquest, and then went on to award...
Didn't his attorney agree to that? Didn't his attorney agree that there would be written submissions?
Your Honor, as I cited in the brief, the Van Schip case of this court states that a legal issue is preserved for an appeal. This was not a factual matter. I believe that this point is still preserved for appeal.
Counsel, I don't buy that legal argument. I think you probably don't want to belabor that too much. It's like you're just asking for a do-over. You're not asking, that doctrine is totally inapplicable to this. It was waived at the mediation or at the discussion with the judge. And yeah, you agreed to, or his counsel agreed to do it on papers. That's what happened.
Your Honor,
I would move on from that.
I'm happy to move on, Your Honor. What the trial court did, the trial court was still required to award damages based on the language of the contract. And what the court did is it dramatically departed from the language of the contract. The contract was a loan participation agreement in which the plaintiff purchased a 4.8% interest in the proceeds of a loan. What the trial court did is it treated it like a promissory note, okay? The court said, we're going to give you back $242,000, which was the purchase price of the loan participation agreement, and then we're going to give you interest. That's not how this agreement worked remotely. The way this agreement worked is you needed to go and look at what actual proceeds were received in loan proceeds, and then multiply that by .048.
Wasn't the loan repaid by the borrower in full?
So, Your Honor, that was never proven to a preponderance of the evidence. They did not have any proof that what they submitted in their damages computation, it was a purely hypothetical computation. They said, here's the loan amount was $5.1 million, and they said, let's just assume that was paid. And then it accrued interest on that amount and said, let's just assume that interest was paid. And
So is it your position that the loan was not repaid?
Your Honor, whether the loan was repaid or not is an issue in separate litigation.
No. Can you answer my question?
Your Honor, the loan may have been repaid, but the important part is the burden
There was
of
no
proof.
default here, right?
On the loan, there was a default on the loan.
Well, but there was no notice of default issued, right?
Well, in fact, Your Honor, there was an email notice of default.
Email was not sent to the borrower, right?
No, that was sent to the borrower. The email was sent to an agent of the borrower. It was part of the borrower's team in London, and that's set forth in the brief. And so,
It
Your Honor,
referenced a concern, but that doesn't sound like a notice of default.
well, Your Honor, I think if you look at the document, you don't need to necessarily have a notice of default. Most of these agreements, and I believe this is one such agreement, doesn't require a notice of default in order
Are you
to.
saying that the servicer did not have to give a notice of default?
Servicer had not given notice. No, the servicer did notify the borrower that they
There are
defaulted.
specific things that the servicer has to say in the notice of default, correct?
Your Honor, I
specific
don't believe
ways to
there was
serve
any
it, or-
specific requirement that there was no question that the loan maturity date had passed, and then there's the email that indicates there's a default. And in such circumstances, you're under Section 4B of
You're
the.
asking us to jump from one puddle to another. I don't get it. There's no paper trail that's marking every event that you're talking about.
Well, Your Honor, so I submit that there wasn't proof that there was sufficient proof there was a default, and so then you're in Section 4B of this waterfall.
There was insufficient proof that there was a default? That's what you
No,
said?
there is sufficient proof.
Oh,
there's a
there
default.
is?
Yes, correct. And so when you're under Section 4B, then the senior loan participant has to be paid in full before the junior loan participant is owed any
So
money.
in the record, does it say how much money the borrower owes?
Borrower owes.
Yeah. If the loan wasn't repaid, if there was a default, how much is outstanding?
Your Honor, these are based on the attempt of proof by the plaintiff in the case, who bore the burden of proof.
You can answer my question. How much is outstanding?
I know the answer to that, Your Honor, but one thing that I must say is very important is that if one computes, even if you accept the numbers that the plaintiff put in, if you get those numbers, what you get, 4.8% of about $6.6 million is about $300,000 and change. And from that must be deducted $67,000, which the plaintiff admitted had been paid. So you end up with about $246,000. Okay, that's crystal clear. That's just math under the contract. Then there are the servicer fees, servicer advances, and servicer out-of-pocket costs. You put in $900,000 of evidence of those amounts. Okay, the trial judge simply blew them off. And as I showed in the reply brief, these documents, these were real costs that were incurred that must be deducted in the waterfall. And there were many things that my colleague claimed were unrelated to this. And what I showed is that, for example, there's a Schneider-Harrison legal bill for $46,000. It says in it that it's working on the Hoovy extension agreement. Okay, it clearly was related to the loan. These were appropriate expenses that should have been deducted in the waterfall. The trial judge just blew it off. What I would suggest, Your Honor, is the court should reverse this decision, make sure, send it back, say that the computation has to be done as 4.8% of amounts received, not treated like a promissory note. You come out with a completely different set of numbers, and the trial court should roll up its sleeves and actually deal with the servicer fees, advances, and expenses, which it just blew off.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. John O'Brien, Berlanti, Nussbaum, and Reitzes for the plaintiff respondent, Lantern Endowment Partners. I won't address the waiver issue, except to say very briefly that an issue is not preserved if it could not have been avoided if brought attention at the proper junction. It easily could have been avoided. It just on this court's rule, that issue is absolutely.
So I'm more concerned with your with your adversary's argument concerning the numbers that were presented and the court didn't really look to the set-offs, et cetera. Could you address that?
Absolutely, Your Honor. So I think it's worth very briefly addressing how this transaction worked. There is a lender, it was Art Capital Bermuda, a servicer, Bluefin, and there are participants. In one case, there was a participant that purchased 90% of the loan, and in our case, it was purchased 10%, then assigned. We ultimately, being the plaintiff, purchased 4.75% of it. And so when the underlying borrower makes payments, they make payments with interest, and then they're paid to the participants in pro rata fashion, essentially. So all of these items are the lenders and Mr. Peck's obligations to account for. Every month they had obligations to account for them, to present the numbers to the participants and to the borrower and to the invoicing. They didn't do any of that. With respect to whether or not these things are proper deductions, they're absolutely not proper deductions. The participation agreements and the servicing agreements say these obligations, these expenses, are exclusively the obligation of the lender, Art Capital Bermuda. So they would only become theoretically deducted if the borrower, there was a massive shortfall and there wasn't enough to pay the participants. Now, if the appellant had done any sort of accounting of this loan along the way, they may be able to establish that that shortfall existed, but they didn't. We can demonstrate these payments because of the special master report that this panel has seen, because in related litigation of the same transaction, the defendant refused to account for the loan, refused to produce any of the relevant documents that would show where these payments were made.
Did the defendant get a offset for the amount that they paid litigating against Butterfield?
Absolutely not, Your Honor. First of all, Butterfield has an 8-figure judgment against the corporate entities there. And the participation agreement makes the servicer and the lender responsible for those fees and Butterfield's fees. This is an argument that these parties have asserted numerous times, that somehow the participants that they are refusing to pay are themselves responsible for the legal fees of the lender and servicer who are refusing to pay them, even when a judgment is asserted against those entities. And every court in which they've raised it has rejected it.
So counsel, the waterfall argument that
Yes.
your adversary was presenting, it is triggered or rests on the premise that there was a default.
Yes, Your Honor.
Was there a default? I understand that your position is that there was an extension and that there was no default. Can
Your
you
Honor,
address that?
To very clearly address your earlier question, which will lead to that one, under these agreements, they are required to send a certified letter, a notice of default, to both the borrower and the participants. That didn't happen. They sent an email that said, hey, you're behind. That day, $105,000 was wired to a different PEC entity, and then the next day, $1 million came in from that borrower to yet another PEC entity. It's also worth noting that the servicer and lender who are supposed to be paid under these agreements were not paid under these agreements. Other non-party entities that Mr. Peck controls were paid. And by the way, those entities have since, because there's judgments against them, gone into bankruptcy proceedings in Delaware, in which trustee is investigating what happened to that money.
I don't understand what you're saying, because from my understanding, Mr. Peck controlled or owned the lender, the arranger, the servicer, and even a Patriot, which initially purchased 10% of the participation. So are you saying that his own entities weren't paid as the borrower made payment?
Mr. Peck's entities were, but not the lender or the servicer. Instead, most of them went to yet another entity, Pegasus, which is not a party to any of these. What happened was the senior participant had access to those accounts, so he needed to move them to not. And those accounts, by the way, are now empty. Nobody knows what happened to the money. That's the trustee's job. But
Counsel, if I may, because you previously had mentioned the special master's report, and I want to just briefly address that along with the schedule that you had submitted. You had submitted both to the court below. But my question is, what, if any, evidence did the other side present to refute all of those calculations set forth?
Your Honor, may I answer your question?
Yeah, please, please.
There's no evidence, there's no dispute of the accuracy of the special master report. Is your question, do they dispute calculations made in that report or calculations that we made?
Both.
Well, Your Honor, their dispute on the calculations, there's no dispute of the accuracy or at least the authenticity of the special master's report. With respect to our calculations, they did not set forth a table or an accounting of exactly how they would do it. So it's not a one-to-one wage. They don't have competing calculations. They just say it shouldn't be treated this way. You should just get back principal, which is obviously not true. And obviously the underlying transaction performed to the best of anyone's ability to tell so. And I would remind the court, not that it needs reminding, that this is a matter of the preponderance of the evidence. And so in terms of, I think, a rather dismissive comment of the court should have rolled up its sleeves below, the trial court didn't get any calculations of any substance. They didn't get any proofs of payments or expenses or any accounting of the loan. They got a pile of hundreds of pages of invoices without any proof that they were ever paid.
Thank you.
Thank you, Your Honor.
Now, one thing I want to make absolutely clear is I heard my colleague say that the default would be the basis for having to deduct those expenses, and that's absolutely incorrect. Now, Section 4A and 4B are two versions of the waterfall, depending on whether or not there's a default. In both of them, the servicer expenses must be deducted off the top, okay? The default relates to whether there's any entitlement to payment at all because the senior participant wasn't paid. But in both cases, you have to deduct the expenses, okay? And it's crystal clear, it doesn't matter where else in any other agreement somebody says one party or another has to pay it. It's crystal clear when you look at the plain language of that waterfall that those expenses come off the top. Now, but what I really want to return to is that the numbers that in the court's judgment just don't work, okay? It's 4.8% of the amounts that were received. If we take them at their own word, the numbers they put in, it's about $6.6 million. You come out with about $300,000 and change, and you end up with $246,000 if you do it using their numbers, okay? And if you deduct, as you should, the costs or the servicer costs, then you end up around $81,000. Thank you, Your Honor.
Thank you. Last case for argument by the appellant only. 75 Street Servicing versus CLST Enterprises.
Thank you, Your Honor. I just wanted to emphasize a few points in this case. The underlying mortgage is classified as a commercial mortgage, but this is the childhood residence of Carl Thompson, one of the defendants. CLST Enterprises is an entity that the bank told them they had to create in order to get this mortgage. There was never any, they paid the mortgage for 6 months after the maturity date for the extension, and those payments were never.
There's a no waiver clause, counsel. That's what you come up against.
Your Honor?
In other words, they didn't waive, the bank or 75 Street, the successor in interest didn't waive anything because there's a no waiver clause in the mortgage.
You can waive a no waiver clause, and the principle of law that this case should affirm and should apply to these matters is that when you are aware of an alleged default, one that's non-monetary, and you continue to accept payments in light of that default, then you...
Counsel, the problem here, as my colleague says, is that the extent that the no waiver clause is defined by. It's got so many components. You do this, you're done. You do this, you're done. You do this, you're done. And I don't know how you get around that.
Well, Your Honor, it's an equity
No
action.
extensions unless it's in writing. How do we get around that?
Are you talking about the request for extension?
And acceptance of payment, failure to insist upon strict performance, not a waiver. Delay or omission to exercise a right, not a waiver. That's in 14.4 of the security agreement. How do we get around that?
Because they, by their conduct, their actions, and their words, have waived the enforceability of that no waiver clause. A no waiver clause can't be a we can do anything we want clause. It can't be waiving fundamental
So
fairness.
what conduct? Because the no waiver clause specifically says that the acceptance of the payments does not constitute a waiver. So what other actions would there be?
Your Honor, that would be contrary to the law, and their contractual provision can't trump the law or equity. You know, common sense can't be a stranger in the house of the law. To say that you can accept payments for 4 years after an alleged default.
Haven't we held that, or other courts held that that is not a waiver, especially when you have a no waiver clause?
I haven't seen a single case that's on point with the situation here that has said that this would constitute, that would apply a no waiver clause.
Thank you.
In fact, thank you very much. Thank you, Your Honors. Appreciate it. Thank you, gentlemen.